let me introduce Diana Torres. Diana is a partner of mine, and she's at Kirkland and Ellis as well, and she specializes in copyright work and trademark work. And Diana, I've already taken way too much
That's all right.
time from your
I was just waiting for you to call it soft IP,
No.
Professor Dauchot.
No. I will not call it soft IP. But Diana, that's her, that's her expertise. And I will hand it over to Diana and, maybe jump in once in a while, but I'll be quiet for the most part. All right, it's all yours.
How many people here believe they know what a copyright is? Oh, come on. Oh, boy. How many people think they know what a trademark is? All right. I'm seeing only a handful of hands. I think you probably know more than you think. But let's talk about what they are. Before I talk about what they are, though, you've heard a lot about patents, and I think the whole world knows how valuable patents are. Well, copyrights and trademarks, which are euphemistically called soft IP in the legal world, are also incredibly valuable. The industries that depend on them, the information industry, performing arts, spectator sports, etc., basically contribute over $1 trillion to this country's GDP. And if you look at just statistics from the Department of Homeland Securities and what they seize every year, which is a drop in the bucket with respect to infringement, it's over $1 billion. So there is a lot at stake with copyrights and trademarks. And with that, I'm going to ask you, how many people see a copyright or a trademark in the first image? On the left, yes. Okay, what do you see?
I see the logo.
Okay, and what is that?
That is a trademark.
Okay, what do you see?
Marble.
What's that?
I see the mark of marble.
Okay, marble. Anybody else see anything else?
Well, I don't know if it's relevant, but at the bottom it says all rights reserved. So I'm assuming it's...
There are some rights there, yes. Anybody see any copyrights?
The character design or the art? Would
For-
be a copyright for Spider-Man.
Okay. And for, what about the trademark?
Possibly.
Okay, anybody else?
Is there a copyright on the Tetris design?
Okay, there is a copyright on the Tetris design. What about trademark? Anybody see a trademark here? Okay. At the end of this class, I want you to go back and look at these two images and think about, if we have time, we'll do it, but if we don't, go back and look at it yourself and see what you can see now after the class. So copyright law basics. Just like patents, the basis for copyright is in the Constitution. And the purpose is to promote the progress of science and advancement of useful arts. Basically, to promote technology and creativity. There's a tension in copyright law, and copyright law has developed substantially since the Founding Fathers drafted the Constitution. But there's a tension in copyright law between protecting the rights of the copyright holders, in other words, the people who created the work or who are responsible for creating the work, and the rights of the public to use the work without it costing an arm and a leg. And the tension is that with copyright holders, you want to provide them with the right to control the exploitation of their work because, first and foremost, that's what they do for a living. And you want to encourage it by allowing them to make money off of their creativity. You allow them to license it. You provide a long duration for protection. And you provide a wide scope for protection. The law balances the right of the public by allowing licenses, by saying, hey, once something is yours, like if you buy a poster, right? The poster may be protected by copyright. What if you wanted to make a copy of that poster to hang up, you know, on the other side of your wall? So you had two. What if you wanted to sell that poster? Well, once it's been sold to you, you can do what you want with the physical object, but you can't exploit it. In other words, you can't make multiple copies and sell them without a license. And then there's the doctrine of fair use, which is going to be beyond the scope of this class, but basically there are situations in which you can use a copyrighted work for your own benefit, for an educational purpose, for a nonprofit purpose. There are many purposes where you can use a copyrighted work without permission from the author. And that's how the law balances these rights. Now, there are two copyright statutes that are relevant here. We're going to be talking mostly about the law under the second one, which is the Copyright Act of 1976, which was a long, long time ago, but not nearly as long ago as the Copyright Act of 1909. The old 1909 Act applies to works that were created before January of 1978, actually just before 1978. The new, now, you know, almost half a century old Copyright Act applies to works created on or after January 1st, 1978. And claims today can arise under either statute depending on how old a particular work is. And one of the ways in which copyright cases are being brought now under the 1909 Act is with respect to sound recordings created under the old Act, basically pre-1972 for various reasons. But you'll see a lot of, if you read any intellectual property news, you'll see litigation involving old songs. And that's because under the 1909 Act, originally, sound recordings were not protected by copyright. So what does copyright protect? It protects original works of authorship fixed in a tangible medium. So if you come up with a poem in your head and you recite it, it may be your original work of authorship, but because you didn't write it down or record it or do something to basically put it in some physical form, it is not protected by copyright. But if you were to write that poem on a piece of paper or even on your computer, because computer memory is considered a fixed medium. If you were to take that same poem and put it down on paper or on a computer or now in a sound recording, you would own the copyright. Examples are musical works, books, movies, plays, photos, artwork, computer code. Computer code is now, copyright is now the primary way to protect source code since the limitations on patent. Website materials, advertising or packaging materials, many, many other things. Anything that is creative and it's fixed in some tangible medium, paper, electronics, some sort of recording, that is protected by copyright. Professor Dauchot mentioned earlier that you can't patent just an idea. Well, you also can't copyright an idea. Ideas are free for anyone to use. Even no matter how original your idea may be, it is not protected by copyright. Copyright protects the expression of that idea. So, for example, if I have an idea of painting a sunflower with a sunset behind it and a blue tree, I can't copyright that idea. But if I actually paint that, I have a copyright in my painting. And don't ask me to do that because I'm a terrible artist.
Diane, can I ask you a question?
Yeah.
So there was the other requirement that it be that it be reduced to a tangible medium, right? Is there such a thing as a non-copyrightable idea that could be reduced to a tangible medium?
If it is just an idea,
So give me an example of an idea that you could put down on paper, but because it's an idea, you can't copyright it.
that brings me to sans affaire.
Ah, okay.
There are common elements that are just not copyrightable. There are, one example is if you have a murder mystery. There's somebody who dies. There are people who are investigating. There may be a foot chase. There may be a drunk. There may be a prostitute. These are common elements in various types of works, including a murder mystery. You can't copyright that basic idea, even if you write it down. There are also aspects of source code that you cannot copyright because they are basically the embodiment of an idea, and they are considered to be, they're basically considered to be not original or creative enough.
So if you have the source code for like 1 + 2 = 3, right.
That is a function, it's an idea, it's
Right.
adding. That is something that you can write down, but you cannot copyright. Copyright also does not protect the sweat of the brow. It doesn't matter how hard you worked on that program for 1 + 2 = 3. It doesn't matter if it took you 5 years to write that program. You can't copyright 1 + 2 = 3. On the flip side, you can copyright the phone book because you can copyright a sequence, even if all of the elements are just common ideas. If you organize them in a creative way, you can copyright the sequence of those ideas. Now, copyright is not just the right to protect other people from to protect against other people from copying your work. There is what is called a bundle of copyrights, and it is the right not only to make copies, but to create derivative works. In other words, to take, the famous example that I can think of is Gone with the Wind, right? I actually don't remember whether it was a book or a movie. I think it was a movie called Wind Done Gone, right? It was a takeoff on Gone with the Wind. Now, there was a whole issue of whether or not that was parody and hence a fair use, but the argument there was that was a derivative work, and you couldn't take the characters and the storyline, etc., and build on it and do that without a license from the original author or the original copyright owner. You have the right to protect people, to protect against people from distributing your work, even if they're not copying it. You have the right to protect against people publicly performing your work. So if you've written a composition, a musical composition, or you've written a play, you have something that's written down, it's a creative work, it's in a tangible medium. Somebody may get up and orally perform it in front of a large group of people. But if they do that without a license, that violates your copyright because you have the right to prevent people from performing your work publicly or from displaying your work publicly. Yeah.
If I'm doing a cover of a song, can I do that or not?
You can do a cover of a song in your own home, and that would be considered a fair use. You cannot do a cover of a song for money in a bar or in a concert hall because you would be infringing the right of the songwriter.
Does it specifically have to be for money, or can it be for like another purpose?
You know what? It does not have to be just for money to be an infringement.
Like, at one example I could give you, like, I remember at a campaign rally, Donald Trump used an Earth, Wind, and Fire song, and they basically told him that that wasn't fair use, but it was a very ambiguous case. Like, how does that work out?
I actually don't think that it was a very ambiguous case. I think that was an infringement.
As a infringement?
Yeah. Now, I don't remember how much of it they used. I don't remember if there was some, there was no parody to it. He was using their work and it came across as an endorsement. But it doesn't matter whether it comes across as an endorsement. They have the sound, they used the sound recording, and so the infringement was not only of the sound recording, but of the composition. And you do it without permission, politics or no, it's an infringement.
What draws the line between like plagiarism, not parody, and just copying it illegally? Because you could take like a song lyrics and then change a few words, or would that qualify under parody?
No, parody is when you're making fun of something. So, Saturday Night Live, right? All of those skits are basically parodies. They're making fun of the people that they're, it's typically political these days. They're making fun of the administration or people in the administration when they're acting out, right? And you can do a cartoon like that. For example, I saw something recently that was a cartoon. I want to say it was of the monuments. I don't remember. I think it was of the monuments, and they changed the faces to be the faces of the presidents to faces of various fascists. That is not a parody because you're not making fun of those presidents. You're not making fun of the original work. You're making fun of the other people. So a parody has to be a commentary on the original work itself.
Do you ever see in Saturday Night Live the Jeopardy skit? You know,
That would be a
Alex,
good example.
they got Sean
Right.
Connery, the guy playing Alex, I'll take, that's parody, an example of it.
Now, copyright
Diana,
notice.
could I just go back
Yeah.
one on the other point here? In terms of, and I think what everybody here needs to be comfortable with is, remember day one, I said, sometimes it isn't black and white. And so when we're talking about public use versus private use, that's what litigation is about. That's why people like Diana are out there litigating, because these are issues we litigate about. So if any of you are wondering, well, what's the precise line between private use, like making a copy of a poster in your own bedroom or something like that, and public use, or playing songs in your home when you have a bunch of guests over, is that private or is that public? Well, okay, that's probably private. But you have a massive charitable event in your home and somebody puts a tent in the back and you're blaring that music. Is that still private? Am I right? That's the sort of stuff that gets litigated. When does that cross the line?
Yeah, in fact, was it you that came up to me once and asked me about your dentist? Yes. There's an attempt to enforce copyrights in music and sound recordings, against medical offices that now play it while you're sitting in the waiting room, because that's a commercial use. And it's a gray zone, but it is probably an infringement. But nobody thought about it, and it wasn't big enough to go after until it started becoming very, very common.
Yeah, this is just really interesting. So even like stuff at the radio being played, or songs on the radio even?
Radio has its own license. And there's a whole lot of debate on whether or not they should have a license. They don't have to pay. But copying from the radio is a copyright infringement. Back in the day when people actually copied from the radio, but yes?
What about YouTube then?
What about YouTube? YouTube, we could have a whole class on YouTube. YouTube, I would say, started out largely as an infringing service. It did. The clips were all copyrighted material. They didn't have any permission. you know, and they were making a lot of money from it. There was no fair use there. There was a little bit of tension, I'll be honest with you, because particularly on the television side, the television studios liked the fact that their stuff was on YouTube. But the television studio lawyers didn't. And so sometimes you'd get the lawyers complaining to Google about content that the producing side was happy was up there. It was a bit of a mess. Now, most of that content is licensed. I want to say it was CBS, it was Viacom, took Google to court. But throughout that process, Google started getting licenses, probably not for as much as the studios would have liked, but most of that content is licensed. And you will now see ads on a lot of the content, and there's a revenue sharing between the studios and YouTube.
So just to clarify, if I have a dentist's office and I'm playing music from the radio, I need a PRO license for the song copyrights, but I don't need a separate license because the radio has its own license for the recordings.
You know, that's a good question. The radio has a license, but you don't have a license to blast the radio, to publicly perform in your office. But I think the issue was not so much the radio. The issue was DVDs and music services, and was yours a satellite?
Yeah, it was a satellite.
I think it was satellite. So in those situations, there are different rights. My guess is nobody would have complained about the radio, but when the satellite radio companies were making money and selling to the dentist's office, the underlying rights holders were not happy that they weren't getting a cut. So, I mean, I dealt with this situation in connection with television and film rights for a cable channel. There were some theaters in Texas and in some other places in the South where they would have movie night at a theater showing The Walking Dead. They weren't charging for it, but they had it open. You know, the theater was open, and it was one of these theaters where you could buy dinner. And so they were selling dinner. And their argument was, we're not charging for it. And our argument was, you're still making money for it, and it's a public performance, which you're not allowed to do because it was open to the public. All right.
You're going to have to keep moving, Diana.
Copyright notice. I know we may not get to trademarks today. Copyright notice. You've all seen the C. There are a whole bunch of different ways you can put notice on your copyright. Notice is not actually required for protection, unless it was something under the 1909 Act. If you didn't, under the 1909 Act, put a notice of your copyright, it went into the public domain. That is no longer the case. Nonetheless, it is still a really good idea for anything that you want to protect as your own to put a copyright notice on it, because it puts people on notice and it deters infringement. Registration. A lot of people ask me, well, how can I get a copyright? You get a copyright by creating something and putting it down into a tangible medium, as long as it has a modicum of originality. Registration is not required. Copyright exists and is protected by law from the moment something is created. Nonetheless, registration has its benefits. You can't sue anybody without a registration. So while you don't have to register your mark to protect it, if you're ultimately going to sue, you need to register it first.
Even just to stop them, Diana, and not collect damages?
What's that?
Even just for an injunction to stop them?
In order to bring a lawsuit in federal court In the Ninth Circuit, there's some question as to whether or not you need a registration or an application, just an application on file. So you can apply today and sue tomorrow. In most other circuits, you actually need to have the registration issued before you can file your lawsuit. It's a matter of standing. If you register at the last minute, right before you bring your lawsuit, you may lose out on some key benefits. Copyright is it's very hard to ascertain what you're losing when somebody makes a copy of your work. For example, if you write a song that you'd like to sell for $2 a pop, but nobody's ever heard of you and they're probably not going to pay you 10 cents. Somebody makes a copy. What are your damages? It's very hard to prove damages for some types of copyrighted works. And so the Copyright Act allows you to get statutory damages. But you can only get statutory damages if you registered before the infringement started or within 3 months of first publication. So, go ahead.
What would the rights be for an owner if they didn't register but then saw an infringement of their copyright?
You can sue, and you can try to prove damages, and you can get an injunction, but you may not be able to get statutory damages. And statutory damages basically say a minimum of X and a maximum of Y. And so you're going to get a minimum of X if you win. I have a case right now that involves newspapers, and our client is finding their articles are being copied by a competitor left and right. But they didn't register any of the articles, and they didn't register any of in fact, they didn't even register any of the issues. But one of the most egregious, actually several of the most egregious infringements have happened recently, and the articles haven't been weren't published first more than 3 months ago. So we're registering now, and we have we will be able to get statutory damages even though we didn't register at the time, and even though the infringement happened before we registered. Registration also provides proof that it's evidence that you actually own the copyright, and it's evidence of when you created the work. So there are benefits, but it's not necessary. Now, copyrights last much longer than patents. In general, it's the life of the author plus 70 years. If you have multiple authors for a single work, it's the life of the last surviving author plus 70 years. And if it's a work for hire, it's 95 years from first publication or 120 years from creation, whichever expires first.
What's a work for hire?
Work for hire is when I hire you to work for me, Professor Dauchot. And I say to you, I'd like you to, write a treatise on patent law. I'm going to pay you for it, and I'm going to own it. That is a work for hire. And that happens a lot in the entertainment industry. It happens a lot in the publishing industry. For a bunch of reasons, it doesn't happen a lot in the software industry, and I'll get to that in a bit. Okay, infringement. Requirements for proving infringement. They're pretty basic. You have to own a valid copyright. You have to show copying. And you have to show that the copying was not authorized. The problem comes in, you rarely find evidence of, direct evidence of copying. You rarely have somebody, on film literally copying your manuscript word for word or sitting at the photocopy machine. You just don't, you rarely get that. So there is a test, and it's called the substantial similarity test. And the closer the similarity, the more persuasive your argument of copying is. Go ahead.
Can you copyright an experience at a physical location? For example, like something like a Soul Cycles member experience or Equinox members experience. Can you copyright that so no other competitor can provide something similar?
copyright protection, original works of authorship, fixed in a tangible medium of expression. Is that in a tangible medium?
Let's say there's like an application that's connected to that location. Could that whole idea of the membership being used through the app to provide a better experience in the physical location, that could be copyrighted?
It's an idea. You can copyright the app.
Right, the app.
You can copyright the app.
Okay.
But you cannot copyright you can't copyright the experience itself. And that's why you have SoulCycle and Flywheel and a whole bunch of others. Now, I just mentioned direct infringement. And direct infringement is when you copy me, or vice versa. But most of the law in the last 10 to 15 years has not been about direct infringement, because that's fairly basic. It's been about indirect infringement or secondary liability. And that's where I'm suing you, even though you didn't copy me. I'm suing you because you contributed to him copying me, and him, and him, and her. So you've done something to facilitate typically mass infringement. Or you've done something to benefit from mass infringement in a situation where you had the right to control. And so if you paid attention to any of the file sharing cases, or if how many of you have used torrent sites? How many of you will admit to using torrent sites? Okay. And how many of you have seen major motion pictures on those torrent sites? And video games? Lots of television shows. Lots of things that people own the copyrights to and that are up there without authorization. For the copyright owners to go around and sue every one of you, it's like playing whack-a-mole. It doesn't make sense. So what they've done is they've identified the people who help you copy their copyrighted works in this way, or who benefit from your copying of these copyrighted works in a way that they can control. And the most famous case, I think, is the series of cases involving Pirate Bay, where the founder of Pirate Bay has been in prison. First he was on the lam, then he was in prison. I mean, he's been notorious. But that is where most of the law involving infringement has been developing, in the secondary liability context. Not that you can't be sued individually, you can, but the law is developing around the secondary liability. Now, as I mentioned before, to bring a copyright infringement case, one of the first thing you have to show is that you own a valid copyright. But sometimes it's not clear who actually owns the copyright. Now, if you are the only person who created the work, then that's pretty straightforward. It's you, generally, unless you copied somebody else. But sometimes there are joint works where you worked with somebody else. Sometimes there are works made for hire, which I mentioned before, when you hire somebody else to do work for you. And sometimes there are these derivative works, like I mentioned earlier, Wind Done Gone from Gone with the Wind. Now let's talk about a hypothetical. You've started a blog, you write a post, it's a huge sensation, and now it's everywhere. And you're psyched, right? Because, hey, this is your first blog post, and it's really popular, and you find it everywhere. But all of a sudden you see, wait a minute, it's not just everywhere, like shared on Facebook or Twitter. It's showing up on other people's blogs, and they're getting credit for it. And some of them are placing advertising, and they're making money for it. You didn't register the work. What can you do? Anybody know?
Register it. It's still within 3 months.
And then? Sue them. Go ahead.
Depending on the type of website you use, like say I use like Blogger or whatever, Blogspot, doesn't that become the intellectual property of the service?
It shouldn't.
Okay.
Yeah, there's some. It shouldn't. It should be your intellectual property. Originally, a lot of the terms of service said the IP became that of the service provider, and I don't know what Blogspot service terms of service say, but suddenly the ISPs, internet service providers, realized that if they claimed ownership of that work, then if that work was infringing, they could be liable for direct infringement. So they started putting in there saying, no, it's your work and you're representing that you own the copyright, but you're giving us a non-exclusive license to post it. So you can't sue us for posting your content on our site. All right. And if you have registered, you can get statutory damages and attorney's fees. All right, joint work. Joint work is work, go ahead.
Go back to the newspaper example real quick. Registering a copyright can be expensive if you're registering a lot of works, and if you're a newspaper site that's pumping out a lot of articles at once, is it even worth it for them to get those copyrights or to register those copyrights? Or do they register every 3 months and register all of the copyrights under a single copyright?
Depends on how big the newspaper is, and it depends on, everybody has a different practice. You can register things as a collective work, and a lot of them will register issue by issue, month by month. You can register 3 months by 3 months. You don't need to register, and as a practical matter, you can't register every article individually. The only time it's worth doing that is when it's within 3 months and you see that it's being infringed and it's valuable. Then you go ahead and register it because you'll get your maximum damages that way. But now a joint work is work done by 2 people or more, and it's with the intention that their contributions will be merged and will be considered one work. So you may be developing a video game, and you may be developing the source code for the action, and you may be developing the characters and the way in which they appear, and somebody else may be developing the music, right? But you intend it to be part of one work, which is a video game. You would be considered joint authors. Joint authors each own, absent some agreement between you, joint authors each have a complete ownership of that work. It's always a bad idea to have joint works of authorship, by the way, but if you do, all 3 of you would own that work. You could each exploit it. You could license it to your best friend. You could license it to, somebody else. You could have all kinds of competing licenses. You could decide to sell it in a particular country, and you could decide to sell it in a different country, or you could both try to sell it in the same country. It becomes a mess, but you have the right to do all of that as long as you account to the others for what you made and you share it equally. The only time that you may not be able to do what you want with a work of joint authorship is after somebody has already infringed it and one author wants to sue for infringement. The infringer may not be able to go behind that author's back to another author and say, can you give me a license, after the fact so that I can get out of my infringement? Some courts allow that, and typically it was allowed, but in more recent times, courts have been saying, no, you can't basically get out of infringement by playing one off the other. Now, here's a typical situation. You start a software business. The software requires an illustration, but you're a lousy artist, so you ask your roommate to do the sketch for you, because your roommate's actually pretty good. Your roommate sketches away, you have a deadline coming up, you put that sketch in your software program, and boom, you meet your deadline, and you release your software. Well, fast forward a year, and your software is a hit, but you and your roommate are on the outs. You're living high in Bel Air in a mansion, and your roommate is still living in that same little apartment. And you've given nothing to your roommate. So you get a letter. You get a letter demanding a share of the royalties for your ex-roommate because she claims she's a co-author. Is she right? Anybody?
Wouldn't those be two separate copyrights, one for the art and one for the source code?
Well, it's a single work, and he's asking for royalties on the software. Anybody think she's entitled? Yes? How many think she's entitled? How many say no? How many aren't sure? Okay. She's not entitled. Because remember, a joint authorship has to be something where you intended your work to be merged into one and you intended to be joint authors. So someone who provides a little bit of help is not a joint author of the primary work. Now, you're right, she may have the copyright to that artwork. Arguably, she gave him a license, at least an implied license, when she said, sure, go ahead and put this in your, presumably she knew what it was going into. But she's not a joint author. Under these circumstances, she's not a joint author, and she wouldn't be entitled to a share of the royalties. Now, let's change it up a bit. You start a software business with your roommate. It's a big hit. You and your roommate have parted ways. But you started it. You started the company with your roommate. Who owns the copyright? What's that? How many think it's a joint authorship? Yeah, I would say in this case, it's a joint authorship. Now, your ex-roommate's new roommate has gotten his hands on the software, on the source code, and he creates a competing program or app without anybody's permission, and you sue him because, hey, look, this is worth a lot of money. You sue him for $10 million. Now, your ex-roommate, she sort of likes her current roommate, so she says, look, I'll give you $1 million. You give me $1 million, and I'll give you a license. Does that kill your lawsuit? Yes? No? In many courts, it would. Historically, it would. But as I mentioned earlier, you can't, in many courts now, you can't retroactively, one author can't retroactively give a license to another to get them out of infringement. Or let me rephrase that. One joint author can't retroactively give a license to a third party to get that third party out of infringement, or out of an infringement claim by another author. Another type of copyrighted work, or another type of copyright ownership is what's called ownership through a work for hire. It's basically a work prepared by one person but owned by another. And the way in which it comes up is really one of two ways. It is a work prepared by an employee within the scope of his or her employment. So if you are if you are a writer for a newspaper and you're employed by that newspaper, your articles, the copyrights to your articles belong to the newspaper. The other way is if you specifically are hired to create this work, but only if it falls into certain categories. It's a contribution to a collective work. It is part of a motion picture or other audio-visual work. It is a translation. It is a supplement or a compilation, an instructional test, an answer, or an atlas. Now, don't ask me why those things are in the list of works that can be works for hire, but that's the works for hire are limited to those, and you have to have a written agreement that specifically says this is a work for hire. So I mentioned earlier that source code is often not one of the things that's a work for hire. So if you hire somebody, if you hire an independent contractor to create some source code for you, if that person's not an employee, even if you have a work for hire agreement, it may not be you may not own the copyright to it. So let's change the hypothetical again. You start a software business or any kind of business, and in this case, a software business, and you hire someone who does freelance coding for other people to help you with the code. Well, you focus on the business development and, big picture things because, hey, you're the big picture person. You pay them. You pay them a good amount because you really want them to focus on your work, not somebody else's work. And, you want them to prioritize. But your agreement is just an exchange of text messages. And, you pay his weekly invoices. Who owns the copyright? Anybody? He does. That's right, he does. Now, what happens if you have a written agreement that says he is doing the work for you and you own it? Who owns the copyright? He does. It doesn't fall. He's developing source code. Source code is not one of those things that you can have a work for hire agreement for. So he still owns it. Now, you have to have a work for hire agreement. Now, I take it back. If you can categorize that source code as being part of a collective work, or maybe the source code is for, an audio-visual work, or maybe it's part of a compilation or some sort of translation. If you can fit it into one of those buckets and you have a work for hire agreement, then you will own the copyright. The other way to own the copyright for source code, if it doesn't fall within the types of works that can be a work for hire, is to have your agreement contain an assignment. So the person who is creating it says, yes, it's a work for hire to the extent that it can be a work for hire, and to the extent it can't be a work for hire, I am hereby granting you and will grant you an assignment to all of, to the copyrights to everything that I do for you. That's how you get around this bizarre limitation on work for hire. Now, derivative works, we talked about that a little bit earlier, when done, gone, but it's not just, go ahead.
Does that, under the scope of employment clause, come up a lot where, say you were working at a music label and you were designing album covers, and while you were at the work you happened to design like a new type of shoe? Could the record label claim, like, because you designed that shoe in our office, we own the shoe, or could, as the employee, claim that wasn't under my scope of employment designing album covers?
The answer to both of your questions is yes. The employer can, in fact, make that claim. The employee can make that claim, and it's definitely in a gray zone. I would say Making shoes is not really within the course and scope of the employment. And while the employee may owe the employer for some materials that they shouldn't have used, or for some time that they should have been spending on the employer's work, that is probably the employee's property. But a derivative work can be many, many different types of things. It can be a translation. So there may be a book that you love, but it's not written in Croatian, and you're a native Croatian speaker, and you want to translate it for yourself, your friends, your family, and your countrymen. That translation is a creative work. It is copyrightable, but it's also a derivative work for which you need a license from the original copyright owner. Musical arrangements can be, you can do a different arrangement of an existing song, and that would be considered a derivative work. Your arrangement might be your creation, and you would own the copyright to it, but it would also be an infringement if you didn't have a license from the original copyright owner. The long and short of it is there are many, many things that can be a derivative work. It's basically something that is adapted in whole or in part from something else that is copyrighted. The owner of the original work maintains the exclusive right to create derivatives, and an unauthorized derivative is an infringement, but an unauthorized derivative is also a creative work to which you may own a copyright that you can't exploit. Now, let's talk about derivative works and who owns them. Your software business, let's go back to that hypothetical. The business you started was inspired by a really, really cool program that was way ahead of its time. The company is defunct or nearly defunct, and it shouldn't have been. Hey, it was just before its time. You were inspired by it. You basically, appreciated the genius of that program, and so you reverse engineered it, and you modernized it by adding some cool new features and the like, and you released it, and it was a huge success. You're interviewed by all the tech press, and you talk about how you were inspired to create this program. And you give credit where credit is due. You're honest. Well, a little while later, you get a letter from a lawyer, and they're accusing you essentially of copyright infringement and saying, you need to turn over all your sales information, you need to, get a license from them for future use, or you need to shut down. And you are like, wait a minute, what are you talking about? Nobody knew who you were, nobody used your app, you should thank me, everybody knows your name now because of me. Is that the right response? Okay, what is the right response?
Not giving it away in the first place.
What do you mean not giving it away?
I mean, not.
Not telling the tech press?
Yeah.
Okay.
Probably be the best.
Perhaps that might be a safer course for you, but I would say that the best thing to have done was not reverse engineer. So, who in this case owns the relevant copyrights to your app? Anybody know? Nobody? The original creator?
I think you would, because he didn't file anything for notice of publishing.
Okay. Remember, copyright exists at the time of creation. You don't need to register it. So you can own a copyright with no registration. But also remember, the owner of the original work has the right to create derivatives, And if the derivative, a derivative is basically an adaptation of the original work. So the owner of the original app, to the extent your app is basically copied their app or their program, then that copyright likely belongs to the original copyright owner. If you created something unique and original on top of that, you may own the copyright to that unique and original addition, but the underlying copyright will be retained by the original copyright owner. So the reality is, you may both have copyrights to your app, but you may not be able to exploit it without his permission. So the answer to the question is, can he successfully stop you from selling your software? And can he get your hard-earned profits? Quite likely. So, what's next? You have your product, you have your company, you have your copyrights. You're ready to start your business. What do you need? This is a transition moment. What's that? A logo. Bingo. You need trademarks.
Hey, Diana, before you go on to that, and I know we could spend a week just on fair use, but can you...
You want me to do it all together or? Okay, copyrights. Copyright fair use. Anybody know what copyright fair use is? How many of you have heard of it? Somebody want to give me a definition? Come on. Go ahead.
What, just an example, I guess, like using a song for a video for like a class project or something like that.
Okay.
Isn't it related to, like, if it's for educational purposes, using the word for educational purposes, that's fair use?
Can be. Anybody else? No? Go ahead.
It's a defense, not a right, that allows you to defend yourself in court if you use a copyrighted work for one of 5 uses, including nonprofit, education, and parody, a couple others.
Yes. It's basically where you are using somebody else's copyright in a way that is not directly competing with them. It is for purposes of commentary or criticism, or in a way that serves a totally different function. For example, the covers of DVD boxes, right? They have artwork on them, and those covers can be copyrighted. Amazon, and Google and a number of other search engines use little thumbnails of those, covers to serve, so when you want to buy one, of the DVDs or the CDs, whatever it is, you can click on it. You know what you're buying. Right? They actually got sued for that, and the court said, no, that's a fair use. It's a transformative use because it's for a totally different purpose.
Question.
Yeah.
And when Andy Warhol recreated let's say the soup can.
The Campbell soup can, yes.
Yeah. What's that?
And he made a profit. What's that? And he made a profit. I would say the court today, I don't know of any litigation involving that. I would say the court today would find that to be a transformative use.
What does that mean, transformative?
It is become something else. It is not, that label is not serving as a soup label. In Andy Warhol's image, it's not serving as a soup label. It's serving as a commentary on society through art.
Just to comment on that, I know that, for example, like big contemporary artists like Jeff Koons and Richard Prince are actually right now like going through a lot of lawsuits because of the appropriation of other images. So it's, even though it might be transformative, I know that a lot of people have gone after these artists.
They have, although the Second Circuit found that the Richard Prince, the copying of that artwork was a transformative use. It was petitioned to the Supreme Court, and the Supreme Court did not take it up. So that was found to be a fair use. I don't like that opinion. I found some of those to be barely transformative and not sufficiently to be a fair use, but clearly the Second Circuit disagreed and found it to be fair use.
This is kind of a question about how flexible these like transformative use policies are. Because
Extremely.
Yeah, I've like seen in TV shows like sometimes they'll just change like one thing. Like for example, in Always Sunny in Philadelphia, they call the Philly fanatic the Philly frenetic, but it's like the same everything. So I don't understand like how do they get away with that?
I'm not familiar with that. It's an ad?
No, it's a TV show. So they just took, like, he's actually called the Philly fanatic, but they call him the frenetic in the show. I assume that was to avoid, like, they don't have the full rights to him, I guess, to use him.
Oh. Are they making fun of him, though, in the show?
I think he was just, like, in it. They're, like, he was something with the plot. But I've also seen it, like, on videos and things, like if they change like a few words of songs, or if they just use the beat of a song but change the words, and they say like
there can be a de minimis amount of copying that is generally not considered infringement, particularly when it's like a few beats that are generic. Okay. But there are 4 factors in terms of what you look at for copyright fair use. There's the nature and character of the work. There's the purpose and character of your use. There's the nature and character of the work itself. There's the amount and substantiality of what you copied, and there's the general purpose and transformative nature of it. It is a very, very, very flexible doctrine, and it has changed over time.
If I'm a performance artist, do I have a copyright to my performance?
Is it recorded in any tangible medium?
Let's say I videotaped it.
Then you have a copyright in the videotape, but you can't prevent somebody else from performing your same steps.
So that's not considered a creative work?
It is, but it's not, nobody else can show your video, but they can perform your movements, because the movements themselves are not recorded. There was actually a case on yoga positions recently, and whether or not those could be protected.
We're going to have an additional class towards the back end on enforcement of copyrights and trademarks and the like, and we're going to hit fair use a bit more extensively there. So, but I asked Diana to touch on it today, just so that you have the concept there, but we'll expand on it as we go on. Trademarks.
All right, trademarks. Now I got to fly through trademarks. What is a trademark? It's any word, name, symbol, device, or combination that's used in interstate commerce and that serves to identify source of somebody's goods or services. That's what a trademark is. It's pretty straightforward. It can be a lot of different things as long as it's used in commerce and it serves to identify source. You can have words as a trademark. You can see the Coca-Cola and FedEx. You can have designs. Actually, the Coca-Cola and the FedEx are themselves designs, not just words. But you can have the Nike swoosh, which is just a design. That can serve as a trademark. And you can have sound. Now let me see if I can do this.
Hold on, I have to unmute my
You're
computer.
on mute?
Yeah. Hold on. All right, it should
Let's see.
work.
Oops. Now I gave it away. How many of you would have recognized that had I not given it away? It serves as a source identifier.
Don't give this one away.
I already did.
How about the second one?
I did.
Oh.
How many of you would have recognized that? Right. Yes. It's a trademark. Now, choosing your mark. Can anybody, other than the ones that I just showed, can anybody think of examples of what they consider to be really good trademarks?
McDonald's Golden Arches.
Yes.
Apple.
Apple.
I really find it funny how Candy Crush copyrighted the use of the word candy in any mobile app.
Okay.
I mean, what's the best trademark you've ever seen?
Go Trojans. Fight on.
Fight on. Trojans.
Okay, so we talked about your source code, your software/video game company before. What's a good mark for your business? Anybody have any good ideas?
Like something that someone can quickly draw. It shouldn't be too elaborate.
Okay.
Simple and easy to recognize.
As the name or as a design mark?
It's a design mark.
Okay. What about as a name?
iPhone.
iPhone for your software company?
Oh, I thought you were asking an example of good trademark.
But that is a good name.
That is a good one, but okay. When you choose a mark, you should think about choosing a strong mark. The McDonald's arches, strong mark. Why? Because they're unique, they're iconic, they stand out. Apple. Apple is a strong mark. Why? Because it's so arbitrary. Who would have thought of Apple as the name for a computer company? It's a red and green fruit, right? Before Steve Jobs, that's what it was. It was a red and green fruit. A strong mark, first of all, a mark is only protectable, a word is only protectable as a mark if it is legal, if it is distinctive in identifying the owner as the source. So most marks are inherently distinctive, and those are the ones that are the strongest. So Apple is inherently distinctive because it's arbitrary. The arches are inherently distinctive because they're very iconic, and you don't necessarily think of arches and a fast food joint, except that McDonald's made that association. There are different categories of strength. There are, as I said, inherently distinctive marks. They can be fanciful, which means they're made up. They can be arbitrary, like Apple, which means they're a common word, but they don't have anything to do with whatever it is they're serving to, that they're used for. Or they can be suggestive, and most marks are suggestive. You can also have descriptive marks. So you can have a descriptive mark that is like, the Red Shoe Company, right? It's a descriptive mark. If it acquires what's called secondary meaning, if it acquires the ability to identify source over time, it can be protected as a trademark. There are some things that can't be protected, and those are basically generic things. You cannot protect just a generic word that does nothing more than identify a thing. You can't protect that as a trademark where you're using it for something that relates to that thing. Now, as I mentioned, fanciful marks are the strongest. Some examples. Anybody can think of examples of fanciful marks? What's that?
Lululemon?
Probably.
Three-peat?
There are some. What's that?
Three-peat? Remember three-peat when the Lakers, I think it was the Lakers won it, and they repeated 3 times, and
I would say that's more suggestive because
Okay.
it suggests the nature or character of what they did.
okay.
Xerox, it's a made-up word. Everybody knows it. Kodak, another made-up word. Really strong mark. Exxon, made up. Haagen-Dazs, also made up.
If a company uses one color to represent the company, is that a trademark?
If a company uses color to represent,
Yeah, a color.
color to represent a,
Yeah, a color. That company is that.
it can be, and we'll get to that. Yes, color can be a trademark. Arbitrary marks are marks, like I said, Apple is an arbitrary mark. It's a common word. Nobody made it up. But it was used for a computer company, and that's completely arbitrary. Another example is Camel for cigarettes. I mean, a camel. What does that have to do with cigarettes? Nothing. Arm & Hammer for baking soda. What does that have to do with nothing? But you'd agree with me, these are all very strong marks, right? Anybody in here not recognize any of them?
Now, when you take Arm & Hammer, what is the mark? Is it Arm & Hammer,
It can, well,
or
you
is
have,
it the picture in the middle?
both.
Both. Okay.
Both. Arm & Hammer is the word mark. The whole design is a design mark or a logo.
So you probably have a bunch of marks within that picture.
You have at least 2 marks in that picture. And I would say same with the camel. Suggestive marks, by far the most common, are marks that require some imagination or thought to reach a conclusion as to what the nature of the goods or services that they're being used for is. And I will be honest with you, the line between what is suggestive and what is descriptive is very, very fuzzy. Coppertone, Chicken of the Sea, 7-Eleven, Citibank, these are all suggestive marks. Coppertone because, it's suntan lotion, you want to have that Coppertone. 7-Eleven because it's a store that was open from 7 a.m. to 11 p.m. Chicken of the Sea because, I guess you could describe tuna as the chicken of the sea. And Citibank because it was a bank in the city. A descriptive term, though, immediately describes a product. It can be so weak that it receives no protection, or it can become much stronger through use over time and, develop strong trademark rights. Raisin Bran, Holiday Inn, Chapstick, these are all descriptive marks that have become strong marks because of their continuous use and the significant investment by their owners.
Can you, Diane, if you could go back, and I know we only have 15 minutes, but what's the difference? I mean, why is Citibank suggestive and why is Holiday Inn descriptive?
I told you, it is a very, very fuzzy line. I think because Citibank is more than just a bank in the city, whereas Holiday Inn was an inn where you went on holidays.
Okay. This is why litigators have a job.
What about Microsoft?
Microsoft, I would say that is a suggestive mark.
But it's like Microsoft.
Exactly.
Isn't that descriptive?
No, because it takes some imagination When you hear Microsoft, it takes some imagination to think about what it is, what type of goods or services the mark is being used for. You had a question?
I was going to ask if the fact that it was spelled C-I-T-I made a difference versus if it was C-I-T.
Yes, actually it does. It does. Now there are some things that were originally strong trademarks, but they became generic. Aspirin used to be a trademark, but everybody referred to the product as aspirin. Thermos. Thermos as a word mark, it's a thing, right? You think of it as a thing, not as a brand. That's what's called genericide. Those words have lost their ability to serve as trademarks. How many people Google things? Google is a trademark, and it's I except that they use it in a very creative a creative font and they have a lot of graphics. It's one of those things that may be in danger of genericide at some point because people say I Googled this, I Googled that.
Like Xerox too.
Most people don't say I Xeroxed anything. It's not you may use it as a verb, but it's not necessarily, it's not ubiquitous. Whereas aspirin, it's an aspirin. Kleenex has taken a lot of steps to make sure they don't become a generic brand. They say Kleenex brand tissue. And that's, it may be just, in tiny print, but that's what they do to protect against genericide. Go ahead.
Sorry, I missed it. You said once genericide happens, they lose it?
You lose the trademark.
And how do you protect it
Hula
from
hoop.
becoming?
Hula hoop is one of those things. They lost the trademark.
But how do you stop that from happening?
You don't call your product an aspirin or a hula hoop.
But you don't know that it's going to be genericized when you first come up with the name.
I don't believe third parties can genericize a mark. It's the way in which the owner uses it. So people look, when you have a mark and it's for a product that nobody else has, in many respects you want people to refer to your product by the name, by your brand name, but that's where you get in trouble if you don't, at least in your own materials, distinguish between the brand name and the product. Secondary meaning is where something that is inherently descriptive or not a traditional trademark can nonetheless become a trademark because people now associate it with source. So you asked me about color before. The color red, this particular color red on the sole of a shoe is considered a trademark. Anybody recognize these shoes? Yes?
I pity your parents.
All right. So, trademarks are not in the Constitution. They are authorized Congress is authorized to regulate them though, but it's under the Commerce Clause. The relevant statute for our purposes is the Lanham Act. States have their own statutes and they're all over the place. There's a dual purpose. First and foremost, the purpose of trademark law is to protect consumers from confusion so that you don't think you're buying brand X when you're really buying brand Y. Second of all, there is a goal of protecting the mark holder's investment in the trademark and the brand. There's a little bit of a tension there between being protectionist of both, protecting consumers and protecting the mark holders on the one hand, and facilitating the ability of newcomers to be able to come up with new marks. Because let's face it, unless you make up your mark, somebody is using like almost every word in the dictionary as a trademark for something. Now, how do you establish trademark rights? You choose a mark, You clear the mark. You know what clear the mark is? Make sure nobody else is using it for what you want to use it for. You can do it informally by just Googling it. You can also, internet searches. You can also go to the PTO website, and they have a database of trademarks. Type it in. See who else is using it. You might come up with a list of 5. You might come up with a list of 500. But it's important to do that, particularly when you're first starting out, to make sure that somebody else isn't using the trademark you want to use for something identical to or fairly similar to what you want to use it for. And then finally, before you invest a tremendous amount in your trademark, do a formal clearance report. If you really have a viable business, I forget what the cost is, but whether it's $500 or $700, do a formal trademark, because you don't want to make your company successful and put money into your brand and develop a whole lot of goodwill and following, only to find out that somebody else is using your trademark. Now, to get trademark rights, you don't just create the logo or come up with the word, you actually have to use it. Unlike a copyright, which exists at the time of creation, a trademark does not exist until you use it in interstate commerce with goods or services. You can use it in advertising, but if it's a trademark, advertising alone may not be enough. Now, unlike copyrights and unlike patents, there's no expiration on a trademark. As long as you use your mark in commerce, you have rights. Now, that doesn't mean that you have rights forever. If you stop using the mark, you may lose your rights. If you let the mark become generic, you may lose your rights. You can also lose your rights if you don't police them. Remember, a trademark is supposed to identify source. So if there are a bunch of other people out there who started using the same trademark you have, or something very, very similar with very, very similar goods or services, you need to do something to stop them. Because if you don't, and that trademark becomes associated with a number of other people, you can lose your rights. If you license, say you become very successful and you start licensing your mark to different people so that they can create, new goods and services, or so they can create all the goods and services and you can sit back and just, cash checks. Well, if you don't police them, in other words, if you don't exercise some quality control over your licensees, you can lose your trademarks. And that's because, remember, trademark law is designed to protect consumers from confusion, and frankly, it's designed to make sure consumers get the general quality that they expect from the source that they think they're buying from. And again, if you don't use it, you can lose it. Now, registration. You can register with the USPTO. Unlike copyrights, though, you can enforce your trademark rights without a registration. There are advantages. Again, you put people on notice. You actually get nationwide priority with federal registration. So, you may not get, if you just use a trademark without registering it, your rights are limited to the geography in which you use the mark. If you use the mark in interstate commerce, say you sell from here to Arizona and Nevada, but you get a federal registration, you're covered throughout the country. And registration is considered prima facie evidence of the validity of your trademark. There are 2 different types of registrations. One is the normal registration. You've started using it, you register it, you tell them, hey, I've used it, here's a sample of how I've used it, boom. You go through a little process. If it's clear, you get your registration. The other is, hey, I know I'm going to use it. I want to make sure nobody else uses it before I do, and nobody's using it yet. I'm going to file a registration on an intent to use basis, and I'm going to tell the PTO this is the mark I intend to use, and these are the goods and services I intend to use them on. And what that does is it secures you a priority date so that you can claim to be using it as of the date of your application, or you can claim rights as of the date of your application, even if you are not yet using it. The registration remains in force for 10 years. Periodically, you need to file some things to, make sure the PTO knows that you're still using it, and that gets you some additional benefits, but the initial registration remains in effect for 10 years. Registered marks are typically, they typically have an R at the end. They can say any number of things, registered U.S. Patent and Trademark Office, but a little R in a circle is a lot more efficient. Unregistered marks, it is very helpful, particularly with unregistered marks, to use the little TM symbol. That tells somebody that this isn't just a word you're using in a descriptive sense, it is your trademark. Famous marks, we're going to skip over famous marks, but Coca-Cola, Google, McDonald's, all of those are famous marks. Remember I said earlier, the key purpose of trademark law is prevent against consumer confusion. Well, if your mark has become famous, such that it's a household name, you can stop somebody from using it, even if nobody is likely to be confused. This is an entrepreneurial class. My guess is you've got a ways to go before you get to a famous mark. Trade dress is the last thing I'm going to cover. Who recognizes that? And that? And that? And that? Geez, more people recognize that. Okay, there's not a single word there. With the exception of Uber, there's not even a logo. This is called trade dress, and it is the overall commercial appearance through the use of color, through the use of shape, through the use of it's an artistic impression that leaves a commercial impression, and that is called trade dress, and that is just as protectable as a trademark.
So going back to the previous question, is SoulCycle's interior design a trade dress?
Yes. Okay, so those trade dress is those features of a product's packaging, appearance, or configuration that contribute to the overall commercial impression of the product, and they serve to identify source, and they aren't functional. It is just as protectable, but it is broader in scope than a trademark, and it focuses on the entire image. So there may be little differences between your trade dress and somebody else's, but if the overall impression is such that they are the same or very confusingly similar, you can have an infringement claim. All right, how much time do we have? Are we out?
We have no time.
We have no time. All right. I'm going to leave you with, you can go through some hypotheticals, but I'm just going to point
Actually,
you to...
that stuff, Diana, the infringement issues,
Yep.
we're covering those at the back end.
Okay. There's at the end, there are a couple of checklists for establishing and protecting copyrights and establishing, and developing and keeping trademarks for your future use.
We'll post this stuff.
Okay.
All right, thanks, Diana.
Thank you.